40 years ago, the Supreme Court said that every child in this country, regardless of immigration status, has an equal right under the Constitution to attend public school. But today, with federal immigration enforcement, ICE, clashing with local public schools all across the country, kids are getting caught in the middle. Hi, my name is Shaunak. I've been a plaintiff's litigator for almost 10 years. That means I represent people, usually against big corporations and government entities, and I love the law, and I love using it to help people every day. I'm going to talk to you about the constitutional right of every child in this country to access free public education, the policy shifts that have made that right tenuous for kids of undocumented immigrants, and the clashes we're seeing now between federal immigration enforcement officials and local public schools, with kids' educations at the heart. This story begins in Texas, where in 1982 the state adopted a law that withdrew state funding for kids of people not legally admitted to the United States, undocumented immigrants. It gave school districts the discretion to deny these kids enrollment to their public schools. One district got creative and implemented a $1,000 tuition annually for kids of undocumented immigrants. Now remember, this is public school. And so those kids, through their parents and lawyers, sued. That went all the way up to the Supreme Court, which held that the Equal Protection Clause of the 14th Amendment protects any person within a state's jurisdiction, anybody, whether or not they're undocumented or not. And therefore, states cannot implement rules, tricks, gatekeeping that prevents certain children selectively from accessing free public education. Everybody in the state has an equal right to public education. How the court got there is the same way any court looks at the constitutionality of a law that is being challenged. They look at those laws under what are called levels of scrutiny. There are generally 3 levels of scrutiny: rational basis, intermediate scrutiny, and strict scrutiny. Rational basis is the lowest level of scrutiny. It's the default level when any law is being challenged. All it requires is that there is some legitimate government purpose behind this law, and that purpose has some rational link to the law itself. The highest level of scrutiny is strict scrutiny, and this is applied when the law being challenged restricts or discriminates on the basis of a suspect class like race, or implicates fundamental rights like speech. For a law to survive this level of scrutiny, the government has to show a compelling government interest, that's way more than legitimate, and that the law is narrowly tailored to achieve that interest. But Plyler didn't fit neatly into one of these two extremes. The court didn't go so far as to say undocumented kids were a protected class, nor did it say there was a fundamental right to education. So strict scrutiny didn't apply. But the court was not really too keen on rubber stamping the law under rational basis. The court said this needs something more than rational basis. So instead of a legitimate state interest, the court said, no, Texas, you have to show a substantial state interest. Not so high as compelling, not so low as legitimate. You've got to show a substantial state interest. Texas said, we'll save money, and the money we save not educating undocumented kids, we will use to improve the education system for all the kids of parents who are here legally. The court said, we're not so sure. There's no evidence those savings would actually materialize, and even if they did, what you're really doing is you're taking away something from kids because of something that you're blaming on their parents. You're punishing them for their parents' status. And in doing so, you are creating a generation of kids without the basic tools for civic participation, which, by the way, is the backbone of our democracy. That's the constitutional promise of equal access to public education in this country. When it comes to kids of undocumented immigrants, the constitutional right for every child in this country to access public education equally is in tension with the federal government's authority to police immigration, to enforce its immigration laws. But for years we avoided that tension because the federal government had a strict policy: do not conduct immigration enforcement in sensitive locations, including schools, except for emergencies. But the internal policies of an executive agency are not laws. Just like at work, if you get a new boss, the HR rules don't change, but the way the office operates does. Similarly, when President Trump took office in 2025, that policy was rescinded. And the message was schools are no longer off limits. The impact of that rescission was immediate, and it wasn't because agents suddenly started raiding every single classroom in the country, but the fear kept kids home. Districts that normally had 95% attendance rates saw those rates decline drastically. People kept their kids home, enrolled them into online programs. those children of undocumented immigrants suddenly saw a real prevention to accessing the type of education that the Supreme Court said 40 years ago every single kid in this country should have. This is a constitutional issue because courts have held that disparate impacts can show discrimination. So even if these policies exist that aren't expressly saying undocumented kids cannot go to school, if they have the effect of doing that, then they could very well be running afoul of the 14th Amendment as discussed in Plyler. With the sensitive location policy rolled back and a far more aggressive federal stance on enforcing immigration policy, districts around the country are taking different steps to see what they can do to maintain those constitutional protections for equal access to free public education. But what they have a hard time doing is just saying no to federal immigration officials because of another constitutional provision, the Supremacy Clause. The Supremacy Clause of the Constitution basically says federal law is the law of the land. It is supreme. An area that federal law governs and controls preempts state laws to the contrary. So if federal law says something about a certain area, you can't have a state law that expressly contradicts what the federal law says. But by the same token, local public schools, which are local government agencies, can't be commandeered by the federal government into enforcing federal laws. So they can't obstruct the enforcement of federal immigration laws, but they don't actually have to help ICE officials to enforce those laws. One of the things schools do is tell ICE officials to get a warrant. Now, when ICE officials are conducting a search, they generally do have a kind of warrant. It's an administrative warrant, though. That's not the same as a judicial warrant. An administrative warrant is signed by another ICE official. But to get a judicial warrant, they would have to go to a federal judge to get that warrant signed. And the standards that would apply would be very different. And the reason for that is because judicial warrants are the process by which law enforcement can conduct searches and seizures on property that are okay under the Fourth Amendment. So without a judicial warrant, with only an administrative ICE warrant in hand, schools generally say to ICE agents, sorry, you can't come onto private areas of our property. You are limited to the public areas of the school. You may ask, why isn't every area of a public school by its nature public? Well, have you ever walked down to your local public school and tried to just barge into a classroom? The same goes for when immigration officials ask for student records. The Family Educational and Privacy Rights Act, FERPA, it prevents schools from disclosing personally identifying information of a student without a judicial warrant or parental consent. That includes addresses, attendance data, schedules, and while there is an exception for directory information, schools are more and more reducing the amount of information they collect so that they don't have the information to turn over if they're asked for it. Pile on top of that, the myriad state laws that are going into effect to prevent districts from collecting certain information that could later be used to identify undocumented kids in the system. It's created a patchwork of rules and a disparity in how undocumented kids access education, despite the fact that there is a constitutional protection for every student to access free public education in the same way. If you want to dig a little deeper into this tension between state and federal laws, between the different branches of government, and how it all comes to a head in pivotal Supreme Court decisions, then check out this video I did on the recent Supreme Court decision expanding presidential immunity. Otherwise, if there's a topic you're interested in you'd like me to address from a legal lens, then drop it in the comments below. I'll do my best. See you next time.